Okay, so I'm going to breeze through the main topics of Chapter 16 because I'm not required to read it, and then the introduction to Chapter 17 in this recording, which is the role of counsel. So starting with Chapter 16, Free Trial, Free Press. This chapter introduces a new participant in the criminal justice process, the media, or, if one prefers, the public, that is the audience of the media. In many situations, the interests of the media and the accused coincide. Indeed, the accused's Sixth Amendment right to insist upon a public trial is premised on the significant value of the public disclosure in ensuring that the trial is a fair one. Henry Oliver, tried in 1948, is the source of that quote. But there are instances when potential conflicts now arise between the media's right to report and the accused's right to a fair trial. Example, in Nebraska Press Association v. Stewart, 1976. The Supreme Court reviewed what had long been its basic approach in responding to such conflicts. The court in Nebraska Press noted that the authors of the Bill of Rights did not undertake to assign priorities as between First Amendment and Sixth Amendment rights, although fully aware of the potential conflicts between them. This placed the Supreme Court in a similar position. It could not rewrite the Constitution by undertaking what they, the framers, declined to do. Rather, it had sought to develop constitutional standards responsive to the particular situation that accommodated both the freedom of press under the First Amendment and the constitutional rights of the accused. The cases in this chapter reflect several different aspects of the court's efforts in this process of accommodation or balancing. Perhaps the most significant source of conflict between the media and the accused arises from the impact upon the jury selection process of extensive media coverage of a case prior to trial. That coverage often starts with the reporting on the commission of the crime and carries through to the eve of the trial, reporting not only matters of public record, but also information developed by the media itself. It produces what the court commonly describes as pretrial publicity. Such publicity, often adverse to the accused and sometimes highly inflammatory, has the potential for influencing the attitudes of a large segment of the potential pool of jurors, but both those who themselves read, saw, or listened to the coverage and others who have heard about it secondhand. So the footnote here, Oliver noted that the public trial serves the defendant's interest in a fair trial in several ways. Romanet 1, the knowledge that the trial is subject to contemporaneous review in the form of public opinion serves as an effective restraint on possible abuse of judicial power. Romanet 2, the presence of interested spectators assures testimonial trustworthiness by inducing a fear in witnesses that false testimony will be detected. Romanet 3, the public disclosure may call the proceedings to the attention of key witnesses who might be unknown to the defense and who might respond by coming forward with critical testimony. And as discussed in Weaver v. Massachusetts, the Sixth Amendment right is subject to exceptions which permit closure under special circumstances. See also the discussion in Waller v. Virginia on page 782. Nebraska Press presented a trial court's... Did I skip? I did not. This is a new paragraph. Nebraska Press presented a trial court's attempt to avoid the difficulties created by adverse pretrial publicity by precluding media publication. The trial court issued a pretrial order that barred the media from publishing reports that, 1, described any testimony given or evidence adduced in court, or 2, included accounts of confessions or admissions made by the accused to the police or third parties other than reporters or other facts strongly implicative of the accused. The Supreme Court found that the First Amendment absolutely barred an order restraining publication of what happened at an open judicial proceeding, here a preliminary hearing. Such an order violated the settled principle that once a public hearing has been held, what transpired there could not be subject to prior restraint. As to prohibiting the publication of information obtained from other sources, the First Amendment imposed rigorous prerequisites, including the clear inadequacy of measures within the criminal justice process that provides a shield against the potential impact of adverse pretrial publicity. While the court was divided as to whether these First Amendment prerequisites could ever be met in practice, the Nebraska Press ruling was seen as basically closing the door to attempts to prevent adverse pretrial publicity by restricting media publications. And then I guess a little bit more of the case details is in the footnote. But before getting there, if adverse pretrial publicity was to be prevented, courts and legislatures would have to look to other measures. Moreover, here too, Nebraska Press indicated the first line of response to the threat posed by adverse pretrial publicity would be to look to the measures that preserve the accused's right to an impartial jury without imposing upon First Amendment interests by restricting the information available to the media. So here's the measures. And it'd be good to write them down. A, change of trial venue to a place less exposed to intense publicity. B, postponement of the trial to allow public attention to subside. C, search and questioning of prospective jurors to screen out these with fixed opinion as to guilt or innocence. D, the use of emphatic and clear instructions on the sworn duty of each juror to decide the issues only on evidence presented in open court. Of these four measures, the defense is least likely to look to the continuance, where a defendant has failed to make bail. Quite commonly in high-profile cases, the defense will want to pursue the right to a speedy trial. Also, while the publicity is likely to decrease over time, it is also likely to resume as the date of the delayed trial approaches. On the other side, the jury instructions known in the Nebraska Press is universally employed. Its value, however, is limited, as the court implicitly recognized in holding that some prospective jurors exposed to adverse publicity must be excluded, even though they state that they will follow such an instruction, setting aside any preconceived notion drawn from the publicity. See example, Irwin v. Dowd, discussed in Skilling v. United States Infra. Accordingly, the key protective measures tend to be the change of venue and the search and questioning of prospective jurors to be the typically voir dire questioning, but sometimes accompanied by juror questionnaires. So there's juror questionnaires, there's voir dire, and there's a change in venue as additional measures, even though they're not listed out. The effectiveness of a change of venue will depend on the distribution of the publicity and the jurisdiction involved. In small states, the publicity may be equally or almost equally intense throughout the state. As for the searching and questioning, its effectiveness depends in part on the standard used in excluding jurors for cause. Nebraska Press spoke of excluding jurors with fixed opinions, but courts have recognized that exclusion cannot be limited to prospective jurors who readily admit to a fixed opinion. Some jurors may deceive themselves and others may seek to deceive the court, a special problem in high-profile cases where some prospective jurors are likely to have a strong interest in being seated. The first case in this chapter, Skilling v. United States, presents a leading Supreme Court discussion of the constitutional requirements regarding 1, the granting of defense motion for a change of venue, 2, the scope of the questioning of prospective jurors with respect to adverse publicity, and 3, the exclusion of prospective jurors. Skilling also has an element only occasionally presented in high-profile cases. The crime involved there had a widespread direct and indirect impact, which combined with extensive publicity and potentially tainting the jury pool. Skilling addresses only constitutional requirements, and jurisdictions remain free to adopt less stringent requirements for a change in venue, to require more extensive questioning of prospective jurors, and to insist upon broader standards of exclusion. In light of the cost of such measures, as well as the doubts of their effectiveness, it is not surprising that almost all jurisdictions have also adopted measures that seek to limit the range of potentially prejudicial pretrial publicity. In Shepard v. Maxwell, discussed in Skilling, within the Skilling opinion, the court suggested that this might be done by a trial court order which prescribed extrajudicial statements by any lawyer, party, or witness or court official which divulge prejudicial matters. So that is also something to be wary of. Responding to that suggestion, trial courts in high-profile cases have issued such gag orders almost always directed to the attorneys and sometimes including other participants. The Supreme Court has not ruled on the constitutionality of gag orders, but Gentile v. State Bar of Nevada, the second case in this chapter, considers the constitutionality of the legal framework often incorporated in gag orders directed at lawyers. All right. Gentile considers the constitutionality of the application of a state rule of professional conduct restricting extrajudicial statements by attorneys. Almost all jurisdictions have adopted such prohibitions, and the vast majority, as in Gentile, have adopted a standard set forth in a version of the American Bar Association's Model Rules of Professional Conduct. Very often these standards are incorporated in the gag orders issued by judges in individual cases, and lower courts have held that any gag order must at a minimum meet the constitutional prerequisites announced in Gentile. However, the combination of rulings in Gentile has produced some confusion in identifying those standards. Note that the division of votes in this case is such that the initial opinion by Justice Kennedy does not set forth the majority position on the basic First Amendment standard defining the state's authority. As provided in parts 1 and 2 of Chief Justice Rehnquist's opinion. Also, because Justice O'Connor did not join either the Kennedy or Rehnquist discussion of the First Amendment standard as applied to the facts of this case, neither opinion reflects a majority opinion on that issue. While Nebraska Press held that the press could not be banned from reporting on judicial proceedings open to the public, it left open the question of whether the First Amendment was implicated in the closing of proceedings to the public and thereby to the press. Richmond Newspapers, Inc. v. Virginia marked the first time the court was asked to decide whether a criminal trial itself may be closed upon an unopposed request of the defendant. Initially, without any demonstration that closure is required to protect the defense's superior right to a fair trial or for some other overriding consideration, emphasis added. No, answered the court, holding the right of the public and the press to attend criminal trials is implicit in the guarantees of the First Amendment. There is no opinion of the court. There was no opinion of the court, period. There was no opinion of the court, period. It led in the lead opinion, Berger, joined by White and Stevens, observed that the Bill of Rights was enacted against the backdrop of the long history of trials being presumptively open, and that the First Amendment can be read as protecting the right of everyone to attend trials so as to give meaning to the explicit guarantees of freedom of speech and press. Concurring Justice Brennan, joined by Marshall, emphasized that public access to trials is essential to achieve the objective of maintaining public confidence in the administration of justice. Richmond Newspapers left open the question whether the right of access to the criminal trial itself extended to pretrial proceedings. The court suggested this possibility in Press Enterprise Co. v. Superior Court in 1984, which is called Press Enterprise 1. When it held without dissent that the First Amendment right of access applied to the voir dire examination of potential jurors. The court emphasized the historical tradition of openness and the functional value of openness for the particular proceeding rather than the characterization of the jury selection process as part of the trial itself. 2 years later, in Press Enterprise 2, the third case in this chapter, the court applied the public right of access to a proceeding that was clearly not part of the trial, the preliminary hearing. The clash between the First Amendment interests of the media and the fair trial interests of the defendant can extend beyond the problems presented by pretrial publicity. Media coverage of the trial can raise concerns even when the jury is sequestered. So the character of that coverage bear upon the ability of the trial participants, jurors, witnesses, lawyers, and judge to carry out their respective responsibilities. Thus, Shepard versus Maxwell, Supra, characterized the disruptive activities of media representative both in the noise and confusion they created within the courtroom and their behavior in photographing witnesses and jurors as they left the courtroom as a key factor in contributing to the carnival atmosphere that pervaded the trial and resulted in the denial of due process. Estes versus Texas, described in 837 to 880, concluded that the television coverage in that case had a similar impact. The last case in this chapter, Chandler versus Florida, addresses the contention that television coverage inherently has such a potential pernicious impact. Although rejecting that contention, Chandler does not suggest that the media has a First Amendment right stemming from Richmond newspapers to insist upon televising trials. Lower courts uniformly have rejected that contention, and some jurisdictions, most notably the federal system, absolutely preclude televising trials, while others bar televising upon objection by the defendant. So this is not standard across the U.S. So televising, not standard across the U.S. So Skilling versus United States is discussed. Wondering if there's like a part 2 of this chapter. Gentiles on page 854. Chandler versus Florida, 877. And then the role of counsel, starting on page 887, chapter 17. There's an intro. There's part 2, the ineffective assistance of counsel. And then the first case will be Strickland versus Washington. And I'm just wondering if this chapter is divided into another subpart. Counsel conflicts of interest. Counsel control versus client control. And the right of self-representation. So quite a few of those sections we're going to get into. Introduction. Chapter 5 examined the constitutional right to representation by counsel at different stages of the criminal process, focusing in particular on whether there is a right to a lawyer provided by the state when the individual, suspect, accused, or convicted defendant is indigent. That constitutional right, whether grounded in the Sixth Amendment or some other constitutional guarantee, assigns to counsel's representation a certain role, providing what the Sixth Amendment describes as the assistance of counsel for the accused defense. That role in turn creates a grounding for constitutional challenges by the defendant as to 1, representation by counsel that is so deficient as to result in the failure to provide the constitutionally guaranteed assistance of counsel, and 2, special settings of representation such as conflicts of interest and governmental restrictions that will prevent counsel from providing what constitutionally guaranteed level of assistance. This chapter considers, in addition to these 2 challenges, a third and fourth challenge also informed by the character of the assistance constitutionally guaranteed, and which is 3, a defendant's assertion that counsel must consult and abide by the defendant's directions on a particular decision relating to the defense presentation, and 4, the exercise by the defendant of a claimed right to self-representation, thereby precluding the state from insisting that the defendant receive the constitutionally guaranteed assistance of counsel. This chapter is placed before the chapter on trials because all of these challenges may be presented and resolved before or prior to trial. Indeed, the 4th challenge cited above ordinarily must be presented pre-trial as the right to self-representation is lost if not timely presented before trial. There is no similar timing requirement for the other three challenges, and here the division in practice between raising the challenge pre-trial and first raising it following trial and conviction varies with the character of the challenge. As to some claims, both pre-trial and after conviction challenges are common. The claim that counsel cannot provide the constitutionally required assistance due to a conflict of interest falls in this category. That claim often will be raised pre-trial through motions of the defendant seeking the replacement of counsel. There's a footnote here after A. In general, the defendant has no right to have appointed counsel replaced absent a showing that 1. Counsel faces an irreconcilable conflict of interest. 2. Counsel refuses to abide by defendant's directive on a decision controlled by defendant's choice. And 3. There has been a complete breakdown in communications between counsel and defendant not brought about by defendant's intentional misconduct. The defendant with retained counsel may automatically obtain the opportunity to replace counsel under the same 3 conditions, but even when those conditions do not apply, the defendant's constitutional right to counsel of choice will prevail if the replacement can be achieved without significantly interfering with the public's interest in prompt and efficient administration of justice. See Ungar v. Serafite of 1964, Constitutionality of denying replacement requests based on timing considerations depends on case-by-case evaluation of the particular circumstances. So, finishing the sentence, the defense counsel seeking withdrawal or the prosecution seeking the disqualification of the conflicted defense counsel. However, absent such motions, unless the trial court directs the defense attention to the conflict and the dangers it presents, the defendant commonly will not be aware of the conflict or is aware, appreciate its ramifications. Thus, the defendant ordinarily is not required to challenge pre-trial his own counsel, even if aware of the conflict, and many defendants will raise a conflict challenge for the first time after conviction. In the case of the challenge based on deficient performance, the objective is almost always first raised after conviction. Even where the allegedly deficient performance occurs pre-trial and the defendant is aware of that deficiency, the defendant has no obligation to challenge his counsel pre-trial, as the client-counsel relationship would be undermined by imposing such a requirement. Indeed, for most deficient performance challenges, the defendant is not expected to raise a challenge even on appeal from the conviction. Deficient performance challenges commonly are first presented post-appeal in a post-conviction collateral proceeding. So, further, subsection 2, this is the first section, ineffective assistance of counsel. The 4 cases in this section: Strickland v. Washington, Harrington v. Reicher, Loeffler v. Cooper, and Weaver v. Massachusetts present the most common challenge to defense counsel's representation, a claimed deficiency in the counsel's performance. For the first of the 4 challenges noted in the introduction, here the defendant is arguing that defense counsel's assistance was so inadequate as to constitutionally require that defendant's conviction be overturned. Strickland, the first case to fully explore such a challenge, described it as presenting a claim of ineffective assistance of counsel, a description today often shorted in commentary and judicial opinion to the IAC claim. Even before Strickland, the court had established that the IAC claim could be used to challenge the performance of retained counsel as well as appointed counsel. As the court noted, the vital guarantee of the Sixth Amendment would stand for little if the often uninformed decision to retain a particular lawyer could reduce or forfeit the defendant's entitlement to constitutional protection. Since the state's conduct of a criminal trial itself implicates the state in defendant's conviction, we see no basis for drawing a distinction between retained and appointed counsel that could deny equal justice to defendants who must choose their own lawyers. And that's a quote from Kyler v. Sullivan in 1980. Strickland, Reicher, Cooper, and Weaver all involve challenges to the performance of trial court counsel, but the IAC claim applies to all stages at which there is a constitutional right to counsel. The scope of that right for these purposes is determined by the right to appoint counsel for the indigent, as any broader right not to have the state preclude defendants' use of retained counsel in other proceedings would be based on a distinguishable individual liberty grounding. Thus, the IAC claim also applies to the representation by appellate counsel on a first appeal of right, see Douglas v. California, establishing constitutional right to appointed counsel in that proceeding, but it does not extend to the later stages at which the indigent defendant has no constitutional right to appointed counsel, since the constitutional guarantee of effective assistance flows from the constitutional right of counsel's assistance. The existence of that right is a prerequisite for the IAC claim. See Wainwright v. Torna, 1982, IAC claim, not available where retained counsel failed to file a timely application for discretionary high court review, as there is no constitutional right to counsel at that stage. Pennsylvania v. Finley, rejecting constitutional challenge based on the allegedly inappropriate withdrawal by a state-appointed counsel in a post-conviction collateral proceeding, as the state had no constitutional obligation to appoint counsel at that proceeding. Strickland is a seminal IAC ruling setting forth the basic standards for determining whether counsel's performance resulted in a constitutional violation. The Strickland decision gave rise to an immense body of lower court precedent, and the Supreme Court itself has subsequently addressed IAC claims in over 24 cases. Reicher and Cooper are two of the latest rulings in that line of cases. Each has a special significance in the development of the post-Strickland case law. Reicher has significant initially because of the procedural context in which the IAC claim there was raised. So I'm not skipping through the footnotes. So footnote B, which probably relates to Strickland, is a challenge to a conviction based on counsel's deficient performance often cannot be raised on appeal because the appellate counsel was the trial court counsel, and a lawyer will not be allowed to create a conflict of interest by challenging his own competency, and 2, assessing the alleged deficiency in performance requires consideration of events and evidence outside of trial court record and therefore not applicable to the appellate court. Accordingly, ineffective assistance challenges under the Strickland standards discussed infra are usually presented in a post-conviction collateral challenge. Here, an evidentiary hearing is available to further develop the claim. So they're saying the appeal can't actually look at like extraneous evidence about alleging ineffective use of counsel, which is why post-conviction collateral challenge is more appropriate, because there's an evidentiary hearing to develop that claim. And the conflict difficulty will be eliminated as defendant is likely to have a different lawyer or will be forced to represent himself, there being no constitutional right to the assistance of appointed counsel beyond the first appeal. See Ross v. Moffitt. Indeed, many jurisdictions prohibit raising a Strickland challenge on appeal. Even when those obstacles noted above are not present, they make the collateral proceedings the only available forum, as all types of deficiencies can be considered in a single proceeding. So Coleman v. Thompson is a footnote on the page I just read from 1991, left open the possibility of modifying this general rule as the collateral proceedings where, under state law, the collateral proceedings provides the first occasion to raise the claim that trial counsel had been ineffective as to such state requirements. The court here noted that an initial review collateral proceeding could be analogized to a first appeal of right, where the defendant does have a constitutional right of counsel and hence to effective representation of that counsel. So Martinez v. Ryan of 2012 concluded that in the context of federal habeas corpus proceedings, where the issue left open in Coleman is most likely to be raised, there is no need to decide whether there was a constitutional right to effective assistance for such an initial review collateral proceeding. In the federal habeas proceeding, the procedural forfeiture of a constitutional claim under state law does not necessarily bar federal habeas review of that claim, where state law limits the defense to first raising an IAC claim as a trial counsel in a collateral proceeding, thereby making it an initial review proceeding, and then procedurally defaults, i.e. forfeits, that IAC claim if it is not raised in that collateral proceeding. Martinez holds that, that's the holding, that equitable considerations allow the federal habeas court to ignore that default and consider the IAC claim on its merits if 1, the claim is substantial, 2, either ruminant 1, the state did not appoint counsel in the initial review proceeding for the claim of ineffective assistance at trial, or 2, the defendant was represented by counsel in the initial review proceeding, but that counsel was ineffective under the standards of Strickland with respect to the claim of trial counsel ineffectiveness. Oh my God, there's another 2 pages before Strickland. Get out of here. 2.5 more pages. Although several of the Supreme Court's post-Strickland IAC rulings have involved direct review of state high court decisions, the vast majority have presented the review that claims raised by state prisoners in federal habeas corpus petitions. That was true of Strickland itself, but when Strickland was decided, the special procedural context had no bearing on the standard of review applied to IAC claims. That changed in 1996 when Congress adopted the Anti-Terrorism and Effective Death Penalty Act. The EDPA established a special review standard for federal habeas cases in which the state court had considered and rejected on the merits the constitutional claim that the state prisoner is now raising in his federal habeas petition. Reichter presents the leading exposition of that review standard as applied to an IAC claim. That standard bears upon not only federal habeas cases, but also the reading of Supreme Court precedent decided under the EDPA by the state courts applying Strickland under traditional appellate review standards. The Strickland opinion establishes a 2-pronged test for assessing IAC claims. Most of the court's post-Strickland decisions have focused on analyzing Strickland's performance prong. In doing so, they have looked initially to the general directives on performance review announced in Strickland, and then in applying those directives, often have further developed their context. Many of the most prominent of these rulings, however, have been limited to special settings, i.e. capital sentencing, that have produced opinions that appear to focus more on differences between the majority and dissent as to the appropriate reading of the record than advancing guidelines for reviewing performance even in those special settings. Reichter, in contrast, stands out as an almost unanimous ruling aimed at providing general directions to the lower courts in the assessment of common aspects of counsel's performance. Cooper similarly stands out as a leading ruling on the prejudice prong of Strickland. Previous rulings applying the prejudice prong have concentrated on the bearing of counsel's incompetence upon the overall strength of the prosecution's evidence, as illustrated by the discussions of prejudice in Strickland and Reichter. Cooper, in contrast, focuses on the basic function of the prejudice requirement as it relates to acquire different type of prejudice and produces a 5-way split on that issue. Moreover, that split, unlike the division in Lockhart versus Fretwell, is not tied to an unusually or a highly unusual factual setting, but to an everyday occurrence, the rejection of a plea offer, combined with the rulings applying Strickland to cases in which defendants accepted negotiated pleas, example Missouri v. Fry in an earlier section, and Padilla v. Kentucky, also near that Missouri v. Fry case, establishes a foundation for the constitutional regulation of defense counsel's role in the plea bargaining process. Commentators have suggested that this line of cases has far greater potential for impacting the constitutional regulation of the criminal justice process than the cases applying the Strickland standards to trial presentations. In part, that noted by the court in both Cooper and Fry, but it also rests on the constitutional regulation of guilty plea adjudication, see Chapter 14, otherwise being far more limited than the constitutional regulation of trial adjudication, which is directly addressed in various constitutional guarantees, see Chapters 15, 18, and 19. Weaver also addresses the prejudice prong of Strickland, but in a context that emphasizes the significant procedural role of the IAC claim, also recognized in Richter. Richter, as stated, page 909, an ineffective assistance claim can function as a way to escape rules of waiver and forfeiture and raise issues not presented at trial. An IAC claim similarly can be characterized as a major exception to the general rule. A guilty plea waives any pre-existing procedural objection that could have been presented prior to the entry of the plea. Whether based on a trial or guilty plea adjudication, a conviction ordinarily cannot be challenged on the basis of an objection that counsel failed to raise or failed to raise in a timely fashion before a trial court. That objection can be taken into consideration, however, by arguing that counsel's failure constituted a Strickland violation. The rules of forfeiture or waiver generally hold the defendant to the actions and inactions of counsel, but that does not apply where the action or inaction reflect a constitutionally deficient performance. Here, the court can consider the merits of the objection not raised and reverse the conviction if the prejudice standard of Strickland is met. Weaver addresses, but does not fully answer the question as to whether the Strickland prejudice prerequisite should automatically be met and the forfeiture therefore excused, where the claim that the trial or appellate counsel incompetently failed to raise a constitutional violation that would be classified as structural in another context, determining whether that violation, where timely challenged, would require automatic appellate refusal of the conviction or be subject to harmless error analysis. There's a million notes on this page. They cite Herrera versus Collins and Martinez versus Ryan and Strickland, but I think the footnotes come from a case I'm going to read later, which is Richter. The significance of the IAC claim as a vehicle for avoiding the forfeiture of claims not timely raised varies from state to state, as all states recognize one or more other exceptions to forfeiture. Indeed, Supreme Court rulings establish another constitutional exception to the context of guilty pleas. Even though states generally are free to treat guilty pleas as forfeiting all constitutional claims not directly related to plea negotiation and acceptance, they must allow a post-conviction defense challenge that rests on the defendant's right not to be hailed into court at all. When the grounding of that claim is apparent on the record, such claims remain open, notwithstanding that counsel failed to raise them prior to the entry of a guilty plea, without regard to whether the failure reflects incompetency. See Blackledge versus Perry of 1974. Plea in which plea did not preclude collateral challenge based on vindictive prosecution. Minna versus New York, 1975, in which collateral challenge based on double jeopardy bar prosecution. Compare McMahon versus Richardson of 1970, when a plea could not be challenged on the basis of an underlying coerced confession. Only avenue to relief lies in the IAC claim that counsel was not reasonably competent in concluding that the confession should not be challenged and advising that plea should be entered. The most prominent forfeiture exception under state law is the plain error rule, which allows an appellate court to consider an error that was not challenged before the trial court and or not raised by appellate counsel. The error must be plain, i.e. obvious on a trial record, which is complete as to that violation, i.e. Had the defense objected, the prosecution could not have introduced additional information which would establish that there was no violation. The error also must be prejudicial, and here the structural errors discussed in Weaver may or may not be viewed as a per se prejudicial in the particular jurisdiction. In many jurisdictions, including the federal, the appellate court's authority to reverse a conviction on an otherwise forfeited error that is both plain and prejudicial is permissive rather than mandatory, and appellate courts will exercise this authority only where the conviction constitutes a miscarriage of justice. Where a plain error meets all these prerequisites, the appellate court has no need to consider whether counsel's failure to present the claim constituted ineffective assistance. An issue may not be available on appeal. See page 8888. However, as with other forfeiture exceptions, the stringent prerequisites of the plain error rule often made the IAC claim the only available avenue for gaining relief where counsel failed to timely challenge a trial court error.